Thanks so much, Mr. Chairman, for holding this hearing. This hearing raises interesting questions. AI surveillance pricing is a new development, and it's one that finds itself at the crossroads of a whole bunch of developments in a bunch of different concerns, including consumer privacy, competition, artificial intelligence, and I appreciate the opportunity to flesh some of these out. Last month, I wrote a letter to Uber and to Lyft seeking some information about whether, to what extent, and what ways their algorithms might use personal data, behavioral signals, or competitor information to help determine rider fares and driver compensation at any given moment. I look forward to their responses, but those questions relate to a broad question before us today, which involves when, whether, to what extent, in what way does legitimate dynamic pricing at some point morph into something more troubling, that raises serious legal and policy concerns? And then what, if anything, do existing laws have to say about that? And are existing laws sufficient to deal with it? Dr. Owens, I'd like to start with you, if that's all right. Now, you support prohibiting companies, as I understand it, from using personal data to set individualized prices. What kind of test, if we were writing a law, what sort of statutory text would you suggest that we use in order to distinguish between surveillance pricing on the one hand and lawful dynamic pricing on the other hand? Utilizing basic inputs like supply, demand, and inventory, as well as time to set prices.
Yeah, I think dynamic pricing can be a useful pricing tool. We usually think of dynamic pricing as factoring things like market conditions into the picture. So trying to manage supply and demand and bring scarce resources into equilibrium. Personalized pricing, on the other hand, is really more about the practice of setting individualized prices, and in the case of surveillance pricing, individualized prices based on data that the company is collecting on you and sort of turning against you.
Using your unique vulnerabilities that they may have access to or may be aware of you more than you are.
Absolutely, information asymmetries. I have to say, I really supported your efforts and think they're really incredible to go after the car companies who are spying on consumers and selling that data to their insurance companies for the express purpose of hiking their premiums. I think that is a really important effort to curtail surveillance pricing in the auto insurance sector, and what car companies are doing to spy on consumers is really problematic. But I do think dynamic pricing has a place in the market in certain settings, but it can also be exploited. I think we all just experienced that with the World Cup, where FIFA used dynamic pricing for the first time ever, and the result was an auction for World Cup tickets, which priced out many of the most loyal and passionate fans and turned the sport into a luxury box for the wealthy.
Yeah. Now, to that end, taking concerns like that into account, you've recommended restricting data pooling and potentially even winding some previously completed transactions in which companies are pooling data sets. Is that right?
Yeah, but also I think the real question with dynamic pricing is, what's the goal of the pricing strategy? Is the goal to maximize revenues, to sell scarce resources to the highest bidder? Dynamic pricing for resources that aren't scarce is really strange. Like, why are we using dynamic pricing for wheat thins? Target isn't running out of boxes of wheat thins when they're.
I mean, it could happen theoretically.
Sure, we've lived through these recent shortages. But typically, what we're seeing with dynamic pricing in grocery stores and with the electronic shelf labels that the UFCW and Senator Hawley have talked about, this is things like hiking up the price of ice cream on a hot day when they know customers need a cool treat.
What sorts of tools or data sets should antitrust enforcement personnel be looking for when flagging instances of these, when identifying surveillance pricing? How best do you differentiate the wheat from the chaff, the good from the bad?
Yeah, I think there are antitrust solutions at play here. There are data privacy solutions at play here. And frankly, I think there really is a need for new laws. this practice, as Mr. Heppner mentioned, is sort of in a legal gray area that's exploiting a lot of existing legal loopholes. And so while I'm interested in FTC enforcement, and I think state attorneys general have an opportunity to pursue surveillance pricing under things like existing UDAP laws, I do think a federal standard would be quite beneficial in protecting consumers here. And then, of course, regulators should enforce that law.
One of the things that you've talked about is making sure that anytime somebody's using an AI purchasing agent, an agent powered by AI, authorized by the consumer to make a purchase on behalf of that consumer, that the AI agent must be required to act in the consumer's best interest. How would you define it and police that?
Yeah, I mean, this is an idea that I've started to write about, and actually Senator Warner has released a discussion draft of legislation, the AI Agent Act, to take this issue on. Look, my concern here is, when someone operates as an agent in the traditional economy, the brick and mortar economy, if you will, they have to act in your best interest. Your realtor has to act in your best interest. Your book agent has to act in your best interest. We have chatbots in agentic AI operating as your agent, planning to go shopping for you, pick up airfares for you, or airline tickets for you, with no similar
expectation of a fiduciary responsibility.
Exactly. And you have to start to wonder, as agentic commerce really reshapes our economy, expected to be a $5 trillion book of business by 2030, what shopping is going to look like if chatbots are shopping in Google Gemini's behalf and in ChatGPT's behalf and not in your behalf. And so this is something that I've been doing a lot of thinking and writing about. I think a best interest standard is one interesting approach. I've supported Senator Warren's approach here, or Senator Warner's approach here, but also think there are a variety of other options worth considering.
Okay. So in other words, I'm out of time, but it sounds like part of what you're talking about is that the consumer needs to know what's happening. And just because it's part of AI doesn't necessarily mean it's foolproof, doesn't necessarily mean that there aren't other influences at play, including acting on behalf of somebody who's a part owner of the agent, or maybe given money to the agent in order to preference their product over somebody else's.
Yeah, absolutely.
Okay, thank you. Thanks, Chairman.
Thank you. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you for having this hearing. And I think you can sense a bipartisan feeling of urgency around this topic, particularly among members of this subcommittee. In my view, we ought to be having this hearing with the full committee, and we ought to be working on legislation that incorporates some of the ideas that have been advanced here. Senator Hawley and I have a framework for legislation. We've also pursued individual pieces of legislation dealing with AI, and I agree with you that there may be a difference, Dr. Owens, between surveillance pricing and dynamic pricing, but for the consumer who sees prices rising, they don't care.